learned trainee mediators and our staff to come over here and to occupy their respective seats. May I request again? I request all the learned mediators to occupy their seats. Once again, at the cost of repetition, I would like to request all the learned mediators, all the learned trainee mediators to come over before the dais and to occupy their respective seats. In a minute or two, we are proposing to commence today's CME program. And I request the technicians at Dharwad and Kalburgi High Court benches to enable the streaming, to enable the learned mediators over there to participate here effectively. I request once again the technicians present over there in Dharwad and Kalburgi to keep the device ready to enable the mediators who participate from that end to have active participation. Good evening, one and all. Today, we all know that we are gathered here to take part in today's CME, and resource person Shri Shivkumar sir, senior mediator and trainer of KMC, is present here, and I extend on my personal behalf and at the behest of all the learned mediators participating here physically, and so also the mediators participating online from Kalburgi and Dharwad benches, a very warm welcome to our Shivkumar sir. Sir, may I now request you to please come over dais. Please sir, please sir. And I extend warm welcome to our learned, respected registrars of Honorable High Court of Karnataka working in Bengaluru, and so also respected additional registrars of Dharwad and Kalburgi High Court benches. And I extend warm welcome to all the mediators present here, and so also the mediators present online from Kalburgi and Dharwad benches. And as a token of respect today, I would like to plant as a token of our respect to Shri Shivkumar sir, the resource person of today's program, and I request sir to receive it.
ಇನ್ನು 2 minutes ಬಿಟ್ಟು ಶೇರ್ ಮಾಡಿ.
I extend warm welcome to one and all, and without wasting time, I straight away request our resource person to commence with this session. Thank you sir. Over to you please.
Thank you sir for that warm welcome. Good afternoon everybody. I'm not sure how many of you are actually happy to see me here, but I am happy to be here. And that's what's important. Today's CME is not what we have done in the past. It is something different. We thought of this idea because of a specific case that arose in the mediation process, consequent upon which there were several legal and factual issues that have arisen. From this case also arose questions about what role can a mediator play, what role should he play in difficult situations where there is an intermingling of law and facts. An intermingling of law not only of counsel who appear in the cases, but also your own personal knowledge of the law. Please remember that there will be a difference between your interpretation of the law and the counsel's interpretation of the law. And the most fundamental difference will be between the interpretation of law by the parties and you. So what is it that a mediator should do is the question that will fundamentally arise in this case. And if you have read the sheets that I have sent you, I have raised a question whether we can develop a standard operating procedure, an SOP for these cases. It's in that background that we are going to be discussing this. Vijwaglu, ideally I would like to be there, not here. But unfortunately that camera is not a moving camera. Therefore I have been instructed to stand still here and say whatever I have to. Please do pardon me for that. We will move on. How many of you have actually read this? It's not a very good number, but nevertheless, have the facts have been understood? Facts are not as important as the principles that we are going to be talking about. First question, do you all know what is a habeas corpus? Does everyone know what is a habeas corpus petition under Article 226? No? It simply means produce the body of. That's it. What? No, dead is not habeas corpus. You produce a dead body, it is not habeas corpus. You can't produce a dead person in court. Habeas corpus is a petition which enforces the fundamental right and says if there is unlawful it enforces the fundamental right against unlawful detention, and the court is empowered in the habeas corpus petition to direct that the body of that person be produced to the court. It is different from a mandamus, it is different from quo warranto in the sense that once that person is produced before the court, does or does not the court have any more jurisdiction? Louder? It does not depend on the prayer.
Hello.
That's right. So if the person is produced in a habeas corpus petition, what is the logical consequence of that production? Matter should end. If the a government notification is challenged as being violative of Article 14 or whatever equality, and the government produces a document which is correct in law, that petition is closed. The relief is granted. Nothing survives. Obviously, therefore, when the body of a person is produced under a habeas corpus petition, the cause of action itself goes. Does it not? Because I'm here, and the petition has been, the direction has been complied with. Therefore, can a high court, in exercise of its jurisdiction as a habeas corpus, refer that case to mediation?
No, not correct.
Why not? In this specific case, the terms of reference was that the parties are referred to mediation to resolve their disputes. There is no dispute. The boy is there. The children are there in the court. So this is... Sorry, I'm pausing because there's a lot of noise coming from there. Okay. So the first question I have raised is, could the habeas corpus petition have been referred to mediation to it all? Let's not get into the legality of the High Court's action. That's a different matter. But what happens if this case comes here? What am I supposed to do? If the petition itself becomes redundant and I have produced the body, what am I supposed to do? This is a live case. This is not a hypothetical case. This has happened a month ago. Hello, can we have some silence there, please? Okay? What does it, now you're sitting, the red file comes to you, it says HC. The court has recorded there that in pursuance of the direction issued, the body of Mr., not the body, the person has been produced. In this case, the 2 children have been produced to court. Yet the matter comes to you. What is your next step? Let's have some answers. Yes, so
Sir, it was sent for mediation between the husband and wife and the children.
Yes.
It can be mediated, why not?
It's a HC.
So
habeas
what?
corpus.
So what? It is irrelevant.
No, wait.
It is not the court that's deciding. Mediation, we should not be looking at whether it's HC, whether it's contempt, whether it's writ. We should be looking at the situation, whether that can be resolved, whether the conflict in that particular situation can be resolved.
It's already resolved.
What
The
is it?
only conflict there was, he has taken away my child. 1 minute. The only allegation was, the father has not returned the child.
Father has not returned the child.
Returned the child from Chennai.
Yes,
The court said, produce the body.
very well.
Produced.
Why, yes. But
Correct.
no, that is for the court.
That's
The
right.
court's jurisdiction is restricted to produce the body.
Uh-huh.
But then they see a mediator there, they said, this is a family conflict, would you mind mediating this matter?
That is the question I'm asking.
Yes, why not?
Because what section 89 says is, whenever their court feels there is an element
Possibility of
of
a
settlement,
settlement.
I am not arguing for this.
Correct.
I am only placing to you the inherent contradictions that are available today. Now what you have said just now is an argument. Do I propose this argument in mediation, or I simply do mediation?
No, sir. What I'm saying is the contempt matters are being referred for mediation.
So let's not divert. I'm talking only about
Habeas corpus.
habeas corpus.
Yes, if there is a possibility of a settlement, no matter what the nomenclature of the case, the matter should be referred for mediation if there is a possibility of a settlement.
Does it fall within 89?
No, then
It doesn't. Then the whole jurisdiction
No.
of mediation is in 89.
No, sir. It is the situation. Then we will bring it under section 89. The settlement will be
So
under section
what
89.
you're saying is therefore, whether or not there is a specific authorization of jurisdiction, once a case is referred to mediation and does not fall under para 27 of AFCON's case,
Yes.
you are entitled to mediate.
We
Is
can-
that the situation here? I'll tell you the problem here. Not the problem. Let me just explain to you what happens. The mediator says the petition has become infructuous. There is no dispute at all. Why has it been referred to mediation? As it happened in this case, both the parties expanded the scope of a HC petition. That's what happened. Now, in an HC petition, the question is, can we look at divorce? In an HC petition, can we look at separation? In a habeas corpus petition, which has ended, the court has become functus officio. It doesn't have jurisdiction anymore. Therefore, a dead jurisdiction body refers something and says, go, mediate. There is no case. The parties may then be talking about domestic violence. They may be talking about dowry. They may be talking about criminal cases. They may want to talk maintenance. They may want to talk child custody. They may want to talk about the quality of cooking at home. Why? You can do that too. Can't we? It's a dispute. So all I am trying to tell you is get you to think, what am I going to do? How will I approach mediation? What will I say in the mediation opening statement? when an HC, only the HC is referred to you, how will you make an opening statement? You can't invite them and say, look, do you have any other dispute? Come, let's talk about it. You can't. Because you're not supposed to do that. You're supposed to facilitate. Now, both the parties sit here. How will you make an opening statement?
So in the same way that I would do any other opening statement.
How?
I would say that you were before the court in respect of a habeas corpus. In the course of closing the matter, the court has felt that there's a possibility, since it's a matrimonial dispute, and therefore they've referred, let's try.
Again, there is no matrimonial dispute. Fine.
Then how did the father have custody of the child?
That is a dispute that is not before the court.
Yes.
Fair enough. Let's not argue here.
Yes.
I'm only placing a point of view.
It is a discussion.
Fair enough. You have said that. I will expand that to say I want to talk about your cooking.
No.
Why? How do you draw the line? Where is the line?
Sir, if the matrimonial dispute is because of the cooking, so be it.
You're not getting the point I'm making. Once we decide to move the line, who determines where the line stops? Who? The mediator? Mediator's rules, High Court rules, Family Courts Act, Hindu Marriage Act, which one? All these three acts that I have here before me are completely silent. And remember, each court under these acts has exclusive jurisdiction in those matters. Just like the High Court has exclusive jurisdiction in 226 matters. Think about it is all I'm saying. So we can't make an opening statement saying mediation is a voluntary process, it resolves conflict, it resolves a dispute. Yeah, Mike, told you.
Then what is the matter we are going to speak before the parties?
That's what I'm asking. That is the question I'm raising so that intelligent
Nothing
and
is there before us.
all mediators here should think about it, because increasingly we are getting HC matters from the High Court. You can do RFA, there's a dispute, RSA, there's a dispute, CMP, there's a dispute. HC, it's finished, it's done and gone.
Matters finished
Go on.
there only, and it's a criminal matter.
Yes.
We can't even take up the matter also.
All right. As I said, without getting into the legality of the order, do you have a clue as to whether an opening statement should be modified?
No. We can't modify.
Modified to what extent? Modified to the extent of telling them that though there is no specific reference, the field is open. Can we have silence there, please?
Can you substitute a part of the opening statement by saying mediation process is usually in the matters of conflict or dispute. Here, technically, as far as I know, there is no dispute at all. But the mediation allows you the freedom and the window to look at other things not directly arising out of this. Okay, suppose you say that. Then the parties arrive at a settlement. Can you record that settlement in HC?
No.
Yeah, then. See, this is the difficulty I faced for how many, not me, the mediation faced for almost 30 sittings. One says this, one says that. Then you have opposing counsel who says it can be done, the other one says it cannot be done. Fair enough. Let's see the HC is disposed of and maintenance issues are decided, custody issues are decided, all matrimonial issues are completely sorted out. You draw up a Section 89 settlement in the Karnataka Mediation Center. Where will you send it? To the HC? Can the HC record this settlement and say a non-existent dispute has been sorted out without an MC number, without a GMC number?
It's a closed chapter.
I'm confused. You must have a JNWC number, you can have a settlement. You can have an MC number, you can have a settlement. You can have a CMIS number, settlement. Here HC, which is finished, and I send the settlement back to the court. What's the court going to do? Is it going to create names? Or is the High Court going to tell the family courts, take this on record, create a file and resort? Plain
No,
taila,
no.
petition illa.
No.
Court annexed mediation we are talking of, not private mediation. Private mediation we can do in conciliation proceedings and drop a Section 73 settlement, no problem. Even that has to go back to the court. But where does the High Court send that order to? I am not clear. Therefore, I said, let's have a chat on this. ಎಲ್ಲಿ ಕೊಡ್ಲಿ ಅದನ್ನು ನಾನು ಈಗ ಪಾಸ್ಪೋರ್ಟ್ ಆಫೀಸಿಗೆ ತೊಗೊಂಡೋಗಿ Habeas corpus ಅಲ್ಲಿ ಹೀಗೆ ಬರ್ದಿದ್ದಾರೆ ಅಂದ್ರೆ ಅವ್ರು ಕೊಡ್ತಾರಾ ಪಾಸ್ಪೋರ್ಟ್? It goes like this. My opinion is worthless. I want your opinions. I'm only triggering your thoughts. That is the purpose of CME. What I did, what happened in this mediation is a different matter. I'm not even going there. My question is, what would you do? Is there any innovative method that you can think of? Huh? Yeah. Mike. Give him a mic, please. Yellow drapa ivalla, please. Somebody else was first. All right, go ahead.
Okay, see, what I think in my view is that since the matter is concentrated on the child's issue, we will talk to the council, find out if they are interested in filing a GNWC case, and then
Okay.
close this. Yeah,
Okay.
close this.
What?
Habeas corpus
No,
thing.
I understood your line of thought.
Yeah.
What are you doing? Ma'am, could we have some silence there, please? ಏನಿಲ್ಲ, ಆಚೆ ಕಡೆ ಹೋಗಿ ಮಾತಾಡಿ ದಯವಿಟ್ಟು. ಕೇಳಿಸ್ಕೊಳ್ಳೋದೇ ಇಲ್ಲ. Okay. If you analyze your statement,
Yes.
what you're saying is, I'm suggesting that you file.
Here, I am not suggesting. Supposing if no, allow 1 second. Supposing in matters where the parties go for a mutual consent petition. ಅದು ಡಿಗ್ರಿ ಆಫ್ ಡೈವರ್ಸಿಟಿ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಡೇಟ್ಸ್ ಆಗಿದೆ. GNWC ಇದು ಇಶ್ಯೂ ಬಂದಿದೆ.
Vaishali, you got bored so soon. So, in effect, what you're saying is, whichever way you put it.
Sir, we are not suggesting, we are discussing with the councils about their views.
One minute.
Yes.
That's a play on words.
No.
It's a play on words. I'm discussing.
Okay.
I'm just throwing an idea at you. Where is the origin?
Now, see.
Where is the origin?
Origin is.
You.
This.
As a mediator, as we have been taught strictly in jurisprudence of mediation, we are not allowed to make suggestions, even if you reframe.
Supposing
These
we
are-
ask the councils, what are your views about this? How would you like to resolve? We are not giving any
What
suggestion.
will you resolve? What is? Please frame the question. I will answer it. I'm the party.
Yes.
HC is here. You want to bring in the subject of children and matrimony. How will you do it? Give me an example, please. And one more thing. I'm not arguing. I'm
We
debating.
are not arguing, yes. Agreed, sir.
Neither are you right, neither am I right. Nobody is right here. There is no empirical right or wrong here. So tell me, how would you tell me?
You want me to say this to the parties or to the councils? What exactly?
That's up to you. These are the questions I'm
No.
asking.
Let me talk to the council about this issue. So I'll have a private session with the councils and ask the councils, Mr. Advocate, what do you would like to do in this matter?
I'll answer that question. Counsel appearing in HC is different from the person who appears here.
They can take
He
a
has
call.
no clue there is a conflict.
They can take a call. Whether they are appearing or not, they can take a call in the matter.
Therefore, your sum and substance of your argument is the origin of the thought, however you put it, has to come from the mediator. In an HC, I'm restricting it to HC.
It's right.
And you feel there is nothing wrong if a mediator, while in the process of mediation, throws an idea. Therefore, you have expanded the scope of mediation, not the parties. These are all highly theoretical subjects, which is why I said you'll feel bored in 15 minutes. So that's one problem. We need to solve it. We need to have some collective action and say, what are we going to do? What is it that we are going to do? Can we as a mediator, therefore, do we have the right to say not fit for mediation? Why not? Why not? Just because it is a high court? No.
Yes, sir.
ಹಾಗಲ್ಲ ಇಶ್ಯೂನೇ ಗೊತ್ತಿಲ್ಲ. We do not, under the mediation rules, we do not have a category of retained cases not fit for mediation. As I mentioned here, it is only in Form 4 and 5, which is an administrative form. And one of the columns says not fit for mediation. Why are we including that column if a mediator does not have jurisdiction? Obviously, there is an inherent discretion there. I take a call. Let's say we go to section Afghan's case, and so it falls under one of the categories. Do I or do I not have the right as a mediator to say that this is not fit for mediation? Translate that, transpose that idea to HC, where there is no other dispute before you, you have no clue about what their matrimonial matters are, nothing. Can I therefore tell the court, look, I can't mediate, there is nothing to mediate here, it's over and done with? That's the next question I have raised. Can we? Can we not? Should we? Should we not? If we do, how? If we do not, how? That's the SOP. How will you frame it? Mere reframing techniques will not be enough. You will have to develop a new kind of reframing and substitution. I am linking all this together to give you a bird's eye view of saying how we all are required to work to develop mediation into larger areas of operation, because things are increasingly becoming difficult and so on. Sorry, ma, I can't hear you.
You have referred at point number 14 that situations that are relevant are the Hindu Marriage Act, the Family Courts Act, CPC and GNWC Act. Even though a judgment and decree has been passed, even though a judgment and decree has been passed by the family court based on the earlier settlement, under the changed circumstances, the GNWC
I have not come. Wait. You are getting a little confused there. Wait. I have repeatedly said that this is the only case before you. Alternative of asking for changed circumstances under 24, this, that,
Yes,
after all GNW, that's a different matter. That's a different matter. Then the problem is solved.
No, they can enter into the settlement itself going before the court.
No.
See, that is pending. The case is pending, habeas corpus case is pending.
No, it's finished.
It's there, they say. Therefore, the High Court did not close the habeas
That's
petition.
right. That's right.
But referred the petition to KMC for mediation. So in that only, the mediator, when she says that it is not a fit case for mediation, we also should mention why it is not a fit case.
No, we are putting the cart before the horse here. What is happening is, the first question I raised was, does the court have jurisdiction at all? But I am not going into that because the High Court can do whatever it wants to under
Habeas
Article 2.
corpus may have anything.
Jurisdiction illa.
Yes.
If you take the route and say that we will discuss all other issues also, where does that thought originate from?
From the clients only.
No, they will not say so. What happened in this case was they said, both the counsel also said, sir, HC is over, why are we mediating? It didn't stop there.
Sir,
It went on to expanding the scope of mediation. By whom? It could have been done by two people. As Jayashree pointed out, she, in her own style or whatever style you have, throw the idea and maybe those guys will catch on it and say, yeah, this is a great idea. We have a great window, let's see what we can do. If she does not do it, how do you get this subject into mediation? In an HC.
sir,
The child and both the children are with the mother because the court directed it. Finished, chapter close. Think about it. We don't have answers today. All I'm saying is I'm just triggering yours because I have another 20 minutes or so, triggering your thoughts on this.
no, sir, what I understood is there are two aspects involved in the given case. One is that legal position, and another is that And the discretionary power of the court, which has passed an order and sent the matter to the KMC. So in a situation like that, can we ignore the court order?
Let me.
Can we ignore the court order?
One nimisha. Do you or do you not ignore illegal orders of the court? Are you bound to follow an illegal order?
But how can we say it is illegal?
It's not illegal. It's not mediatable. There's a difference. For example, I cannot say the judgment of the High Court in this case is wrong. I can't. I'll be held for contempt. But that's not what I'm saying. The question I'm asking is, can I mediate? If so, where is the source? Moola yellide. Moola ne illa.
No, in one word we have to say, of course, as in the Form 4, one clause is stipulated saying that it is not fit for mediation. We can invoke that clause.
That's what I'm saying. We have it in the form, but we don't have it in the mediation rules. So think. All I'm saying is just think about it. Okay. As she pointed out, Shweta, if along with the HC petition, parties have also filed GWC, MC, whatever petition under the Family Courts Act, Hindu Marriage Act, whatever, then there is vesting of jurisdiction in the mediator. That is the starting point, because that is the dispute, that is the conflict. In an HC, there was a dispute, there was a conflict, a judicial order, finished. Ma'am, you haven't read the facts. I am saying there are only HC is referred. Nobody knows there are other cases. Only HC is referred. If the other cases are already pending, HC is for what? You can't get a direction from a family court to produce the body of so-and-so. A habeas corpus petition is under Article 226 for enforcement of fundamental right. It's in the nature of a mandamus to produce the body. Finish, that's it. At the same time, while the HC is pending, if there is a GNWC, there is a C-base and all other related to other matrimonial matters under the Family Court and Hindu Marriage Act, then you get jurisdiction to mediate not the MC, HC, but the other matters as a part of the reference surface. It's what we call extended jurisdiction, assumed jurisdiction. Then it becomes irrelevant whether you have jurisdiction or not, because what you are mediating is the GNWC and the MC, not the HC. This is the contradiction that we are facing. Again, I am not arguing for or against. I'm just giving you a variety of opinions on this.
Sir, keeping this aside, what you've given as the written material, if there's a situation that arises before the court in a HC matter, where it's obvious that there is a matrimonial issue, and can that matter not be referred to mediation?
No, it can be referred, according to me, only in one way. The High Court, in exercise of Ravi, what is this? Answer. You have to switch off the mic. No, you have to switch that. You don't switch off the mic. Okay. My view, it may be completely wrong. I don't know. I'm just thinking about it. There are two things that the High Court can do. Body of so-and-so has been produced. Petition has become infructuous. Dismiss. Closed. What it can also do is to say that I will refer this issue to mediation. Pending that, custody will be with so-and-so. Interim order can be passed. Then I get jurisdiction. But what I'm getting before me is a closed case with a judicial order saying the consequence is that. Think about it.
No. What happened in a case where...
No, don't go to cases. Go to principles.
No, in the sense, it was obviously a matrimonial issue wherein the parents had taken the daughter and gone. So, they were keeping the habeas corpus open, they called upon Lakshmesh and me to mediate. So, we did the mediations, a couple of mediations in the High Court. What happened, that's a different issue.
That's a different issue.
So, that's a conflict they tried to resolve while keeping the habeas corpus pending.
That's the same thing I'm saying. What did I say? I said the same thing.
Don't close the issue. They don't close the petition.
Arey Baba, that's exactly what I said. I said the High Court can do two things. It can close that HC and say finished. Or it can say we will keep that pending. Let's see if there is any other conflict, provided that conflict is actually identified. Yes, this is exactly what I'm saying. You and I are on the same page, fortunately, for the first time on this, on this issue. Okay, so that's the issue that I have raised. The next more important issue that I have raised is, in this case, there was a matrimonial case of divorce. Terms of custody and all that you have read. 70%, 30%, this, that, and all that is already on record. Remember, it's a mediated settlement which has converted into a decree of the court under the Family Courts Act and the HM Act. The larger question that bothers me and that I have raised is, in a mediation proceeding which arises out of HC, not from the MC, can I have jurisdiction to alter those terms of a decree, not a settlement? No. Consent decree can always be modified. If that MC case is referred to mediation, we can do it. Or if there is that 24-hour change circumstances or whatever. That's not what I'm asking. HC is referred, MC passed earlier, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, and that case, decreed as prayed for under the terms of a mediation settlement. Terms are put there, maintenance, education, you've read all that. That case is not referred to mediation. It's over because there is a decree.
Yes.
And that court has become functus officio. The family court has become functus officio. The moment it signs on the decree, no longer any jurisdiction. So it's a dead case. You can enforce that decree. You can file execution proceedings against the decree. Done, you do that. But when the HC is referred, even by consent of parties, if they agree that we will change clause number 1, clause number 2, clause number 3, clause number 4,
No.
which is in direct contradiction to the terms of a decree, can it be done? So
No, we cannot sit on the judgment or decree of the family court.
it is
No,
not sitting in judgment, ma'am. It is altering.
A decree. It cannot be modified.
It is not modified. Yes, that's right. It can be altered. You have to go to 152 or go to 24 and a month.
151.
What? 24?
Yes.
Whatever. 24?
Yes.
Okay.
Unless it is patent or obvious.
So then, what purpose is served by doing mediation in HC?
Nothing.
If I cannot change the terms and conditions that have already been agreed upon in the MC, terms and conditions about child custody has been agreed upon, maintenance has been agreed upon, visitation rights have been agreed upon. Husband says, if you come to, I come away to Bangalore, then the visitation rights will stand changed to 50-50. I will bear this cost, that cost, this cost, etc. Both have agreed and have acted on it for 4 years.
Yes.
Nothing prevents them from going to the appropriate court and asking for modification.
Yes.
They don't do that. They go through the HC route, and when they go through the HC route, am I entitled to say, even by consent of all of you, I will amend a decree?
Yes.
Can we do that?
Cannot.
You cannot. So these are the problems that arise in HC, I'm saying. Look how difficult it becomes. In this particular case, all the demands were contrary to what happened. He says, you come to this place. She says, you come away here. She wants a lump sum figure of some 44 lakhs or 50 lakhs or 60 lakhs for reimbursement of expenses incurred in the past for the child. And they have their own story. That's a different matter. Is the HC a forum to listen to that?
Not a bit case for reference.
Assume I listen to it. I have private sessions, I understand the conflict, I do this, I do that. And because we are able to resolve the conflict, we agree on terms. And say, all right, we will make it 50-50. I will bear only these expenses. How do I translate that into amendment of a decree of a court, which is already passed? I am asking a question how they agree. They say A, B, C, D, E were the original terms. These are contained in a decree. In the HC mediation, they say we will make it DVFBHGH. What settlement do I drop in HC? If I do drop a settlement, how does the order of the family court or a decree of the family court get altered by a mediation in HC? It's not possible. And the HC cannot exercise jurisdiction under 226 to amend a case. It's not possible because there's under the Act, the Family Court and the Hindu Marriage Act also the exclusive jurisdiction. There's an excluding factor. And in one of the, I think the Hindu Marriage Act or one of the, it says notwithstanding any other law contained any other for the time being. It's a non-absente clause. So we have pockets of jurisdiction. Family Court has jurisdiction. Hindu Marriage Act has jurisdiction over specified matters as written in the schedule. In an HC petition which relates to enforcement of fundamental right to produce the body, can I override the decree of courts? Executable decree. What is the effect? I am nullifying that decree. I can't execute that decree. What will I execute? The original decree or this HC settlement? The only way a HC order can be executed is by producing the body. That's it. Nothing more. So think about it. This is enough confusion I have created. I'll create just a little more and then we can all go home and eat your dosa or whatever you want to eat. Okay. Yes, you see question 8 that I have put. How does mediation ensure that the changed terms, if agreed upon by the parties, are incorporated into the decree of the family court? Can a mediator's statement alter a validly passed decree by the family court? If so, how? Just tell me how. I want to learn myself, I want to learn. I don't know how. I have no clue. Unless you file a petition in the family court for alteration. Power ide alva. You can ask under changed circumstances, we can do that. That is valid because the acts provide for those provisions. But if that is not there, please tell me how. How do I do it? I'm stuck. I'm actually stuck in this case. I don't know what to do. I don't know what to do. It's very simple. Counsel argues, sir, you ಮಾಡಿ ನಾನು ಮಾಡ್ಕೊಂತೀನಿ. ಏನು ಮಾಡ್ತೀಯಾ? HCಗೆ ಹಾಕಲಾಯ್ತು ತಗೊಂಡೋಗಿ. Are you going to file this settlement in the HC? So, the next step is what? What Jayashree said. Suggest to them that you file an amendment. That's not my job. It's not my job. It's not my job at all. So, everywhere we go in this whole setup, there is some kind of an unseen barrier here. How do we remove that? This can happen only if all of us get together and understand the issues involved and prepare what we call an SOP, or at least guidelines for that matter. The rules cannot provide for it. Rules only give effect to the act. And I can't specify 300 situations and say this is what you will do, this is what you will do. So do you think there is a need for some group, some study group to sit and see, let's develop a new model of mediation specifically related to these contentious cases where like this may be required. All right, that's question number 8. The next question that I have asked is question 9. If this is the issue, what is the process that a mediation, where is that? Sorry. What is the procedure to amend a validly passed decree by the family court? Does mediator defer mediation in the habeas corpus petition until the parties file a case? No, that's right. This is the argument I wanted. I wanted discussion. No. Your mic, please.
Which court, and our role as a mediator is to ensure that the barriers are removed, and we need to address those barriers. So if the part, sorry I'm late, but I don't know.
Yes, I know you missed a large part of it, so the question has already been answered.
Yeah, okay, very well.
Question is all I
have nothing more to say then.
Well, no. Even if the parties agree, I have created a scenario for you where only one case is in mediation, HC. If there are 4 other cases, this whole lecture is meaningless. Sorry, this whole discussion
Let
is
us assume, let's take another example. Now, when let us take a situation
May,
where...
may I complete?
Oh, sure.
May I complete, please?
You asked me a question, I thought...
No,
I'd
I
answer.
didn't. I asked myself a question. Okay? So, my only, and I am not challenging the views of anybody here. I'm asking everybody. I am not propagating a position of, Arey Ravi, what is going on here? Let me be very, very clear and emphatic. I am not propagating any position of law. I am not speaking for, nor am I speaking against. There can be as many views as there are mediators here. Some may be, there is no empirical right, there is no empirical wrong. It's just a question of a perspective. What is our objective in mediation? First question. That's very clear. In traditional mediation under 89 Code Annex mediation, the object is very, very clear, there is no problem. When complications of this kind arise, the question is, what shall we do? That's it. And that's where collective thought is required. I am only placing before you the issues that have been faced out of this, so that we do a little thinking and see. The intention is good, na? We will identify conflict even in an HC. We will go deeper into the matter and see, would you like to resolve some other issues, etc., etc., etc. The question is, assuming you do, assuming the changed terms are there, how do I incorporate that into an executable decree passed by a court validly exercising jurisdiction to the exclusion of all other bodies? How do we do that? This is a question that I'm raising. Do think about it. Another 10 minutes, I'll close, then you can go ahead. All right, now let's get to number 11 before we get to the others. What is 11 is, can a mediator enter upon discussions or argue in mediation of the legal position and the process to be followed, more so if counsel insists the terms of the decree of the family court can be altered?
No.
I did it, and that was wrong. It was wrong.
Wrong.
Yes, it was wrong. Because the position of law was so atrocious that they were propagating, I moved into lawyer mode, which was wrong. Then I realized this is not the right way to do things. So what is the right way to do things? Do we have a private sub-caucus with the council? Or do we exclude everybody else and talk only to the parties? In this case, whoever was there, the parties did not even understand what we were saying. There was so much technical jargon that was going around. And both counsel contributed to that also, because everyone was happily displaying knowledge of law, including this stupid mediator. So, what do we do? They must be told, na? What is happening in mediation today? Mediators, young juniors who don't know the basic provision of law are coming. I had that miserable experience today. No clue of what Order 21 is. No clue. And then you try to explain to them what is a quo warranto, you try to explain to them what is a habeas corpus petition. Their look is, that's the look. So, what are we going to do, guys? How is it that we're going to take these cases forward? We are at a stage in mediation where law has begun to intermingle with mediation. It is not as though there are two pockets separately operating. It's not there. And the proof of this intermingling and harmonious blending is harmonious or disharmonious blending is the Mediation Act. It's statutorily controlled, but strategy is not controlled. Remember, clubbing two subjects, it's like the substantive provision of law versus a rule-making power. A rule only aids substantive law in achieving the object. Similarly, mediation is substantive, should be, but we are intermingling it now. So are we required as mediators to consciously make an effort to separate the two, educate parties that these are two different things altogether, that in this case, if only the HC is decided, you will get no relief. The only way you can get some relief is either to go under the Family Courts Act or 24 or whatever, and file your necessary applications. Then I get jurisdiction. Not in Salmon's point of view of jurisdiction, but I'm entitled then to start the mediation process, which then is not founded on illegality. It's not illegal. If there is no dispute before me and I start mediation, I have assumed my right. I have assumed the subject. Is that allowed is a question I'm asking you guys. People from mediators from Dharwad, would you like to contribute? Dharwad and Galbagi. Are you able to hear me? There's a time lag, Ravi. We are back. We are 3 minutes back. I'm not even lifting my hand, but the hands are being lifted. Dharwad, any questions? See, it's going backwards. So, please get audio. Ask them if they have anything to say.
Dharwad bench.
Sir, we have nothing to say, sir.
I have nothing to say.
Hello. Hello.
Yes,
From
sir.
Gulbarga, sir. I am from Gulbarga.
Yes,
Audible. Audible.
Please go ahead. Please go ahead.
Hello. Sir, I am from Gulbarga, sir.
Yes, please.
Sir.
Yes, go ahead.
In mediation, in serial number 8, my lord.
My lord, I am
8.
not my lord.
Sorry. Just, I must say. That is daily, that's why I told you. Item number 8, my lord. 8, sir. 8, sir.
8. Okay.
How does mediation ensure that change terms, if agreed upon by parties, are incorporated into the decree of the family court? Can a mediation settlement alter a validity past decree by the family court?
Yeah.
Sir, habeas corpus only comes from the High Court only. Then High Court Mediation Center can settle the matter. It is not referring to the family court.
What matter can it settle?
Sir?
What matter can it settle?
Habeas corpus.
Yes.
Habeas corpus.
I have no problem. Habeas corpus, of course, the High Court can decide. No problem.
No, then family court does not come in the picture.
That's the point. That's precisely the point. The jurisdiction of the High Court in a habeas corpus petition is limited to the relief that the Constitution itself grants.
Yes.
That's it. Now, if that case is sent to the Karnataka Mediation Center or Dharwad Mediation Center, and both parties agree that we already have a decree of divorce that contain terms of divorce, but we want it changed, and they change the terms, and the mediator draws up a Section 89 settlement, where do I produce that settlement? Can the High Court say in the exercise of my power under habeas corpus, I direct that the executable decree in MC number so and so shall stand amended? There is no power.
Yes. Yes. High Court has powers.
How? And in HC?
In MC, not in MC, but
No.
that is referred to the mediation center.
How can a High Court, unless there is an appellate proceeding pending, direct that a case which they don't even know of, which is not before them, it is before the family court, which is an exclusive court of exclusive jurisdiction. Can I therefore say that you shall amend that decree?
High Court can amend the decree.
All right? That position will be tested at some point of time. But to me, it appears a little illogical. It is like saying that the High Court can pass order in the habeas corpus petition saying that all laws in this country shall change to so-and-so. There are very, very clear lines of jurisdiction drawn both under the Constitution and under the specific laws that we are talking about. However, your view is your view, fair enough. There's nothing wrong in holding the view. We will move on. Any other questions from Dharwad or Kalburgi?
Because, sir, it is only habeas corpus is referred by the High Court only for the mediation, not any family court or any other courts, sir.
No, I didn't get
That's
that.
why that is my opinion, sir.
Fair enough. Your opinion is, I'm not dismissing your opinion. You are entitled to your opinion just the way I'm entitled to my stupid opinion. I mean, that's a different matter. But my request is, when we are faced with such situations, our duty as mediators is to go into depth of the issue and not find superficial solutions and say, yes, we can do it because the High Court has referred it. We need to analyze. Because once we do analyze and get to the root of the matter, as we call it, the problem gets solved and you're setting a precedent for the future. Today, all of us will do whatever we wish to do within the given campus. But if we do have an SOP, then probably the question will be made much easier. Now, I think I've generally covered everything. You're already at 5:30. I will close this by only repeating my request. A group of us who are keenly interested in making this mediation movement a little more lively, a little more broad-based, rather than doing the same old 498 days, this, that, and so on. Let's move into broader areas. Mediation internationally and is growing in a variety of ways, and these are the issues that will arise. Fundamental rights will soon become a part of the mediation process. Just watch it. Because the last comment I will make is, every fundamental right is enforceable. But if you do not want to enforce a fundamental right, none can compel you to do so. If we are able to expand that principle administratively, jurisprudentially, then our job of dealing with fundamental rights, including HC, becomes easier. Thank you for listening. I hope you've got some. Where do we stand? You're not standing at all, you're sitting. So, I don't know. There are mediators here.
No, because
there are
we have
very.
given the problem. What is the solution?
I am not here to find solutions. You have to find solutions.
That is wrong. Many newcomers are there.
It's no.
So at least you should encourage by saying.
I'm encouraging you, saying.
No, you are giving troubles by creating problems.
No. Listen, I am making a very positive suggestion.
No,
that
what
there
is
are
the net result?
listen,
How to go ahead?
no, Are Baba, listen. There are very senior, experienced litigating lawyers here. Get yourself into a group and call yourself a study group and analyze it and come up with an SOP. Self-help.
An order of the court, could it be amended?
ಅದು ಸೊಲ್ಯೂಷನ್ ಇಲ್ಲ ಏನು.
Parties decide that they want something different from what the court has decided. Now in a contempt.
Wait, not court has decided. Parties have decided, which has converted to a decree.
Okay. Now, what about a court order which says this is how things should be done. Okay, and a contempt is filed because that order is violated. Now, in the contempt, they decide otherwise. What happens?
My personal view you are asking? My
Yes,
personal
yes.
view is a contempt is not between the parties, it's between the court.
That's what I'm saying.
So it has to be a judicial order. You can't mediate.
Yes.
Contempt you can't mediate.
No.
Yes.
Several matters have been referred and parties have come to settlement. Parties have come to an understanding.
One minute. Just let me stop you there for 1 minute. There is a contempt against you for having violated a court order of injunction. Okay, against Zahir. Zahir is the violator. You are a contemptor. You are, hello please. Hello. Can I have silence there? Hello. You are committing contempt of what? Court. Court order ala court. All right. Now, if that matter is referred to you for mediation, and you as the contemptor say, I will tender an apology, that's the only thing you can do in contempt. No, tell me, don't say no. Come to the principal, yeah, please, quickly. Okay, come on.
Now, what happened? It was 35% of the property was to go to X and 65 to Y. Now, Y did not execute the release deed in respect of 35%, and therefore the contempt was before the court. Now, in court, after so much of discussion, Y decided that we will go 50-50 and a release deed was executed in respect of 50% of property. Forget about 30%. So, and that is what was settled.
Done. I am not talking about a private settlement between two of you.
Private settlement in a contempt.
Vaishali, 1 minute. Vaishali,
Yes, 1 minute.
you agree on 50-50? That dispute between two of you is sorted out.
Yes.
The only way you can do this is to file the settlement and request the court to drop contempt proceedings.
Yes.
Do it.
That is what was done in a contempt proceeding.
Okay, so what's wrong?
No, so a settlement can be arrived at whether it's habeas corpus, whether it is contempt, whether it's a
That's your view?
PTCL.
That's your view, fair
Yes,
enough.
yes.
There is somebody from Ravi, somebody here. Dharwad or Kalburgi wanted. ಯಾರು ಕೇಳಿ ಇಲ್ಲ ಈಗ ಇನ್ನೊಂದ್ಸತಿ ಕೇಳ್ತಿದ್ದಾರೆ Is there any other question? Huh? All right. I will conclude this by saying, if there are 50 mediators present here, there is 150 views. No problem. I'm willing to live with it. I'm willing to happily accept it because I'm not here to propagate one specific point of view. The intent of today was tickle your brains. Thank you so much. It's been a pleasure. Thank you for listening.
Only some new
Have a great evening.
enactments, some new amendments.
I request all the learned mediators to take your seats for a minute, please. I extend heartfelt thanks to Shivkumar sir for engaging all of us, and I hope there are no questions from Dharwad and Kalburgi benches. And I thank every participants who have been participating till now here physically, and so also to all the learned mediators of Dharwad and Kalburgi. And I extend our heartfelt thanks to our Board of Governors for enabling us to arrange a program of this kind. And I extend sincere thanks to all the learned registrars of High Court of Karnataka, Bengaluru, and so also the additional registrars of Dharwad and Kalburgi. And I extend our sincere thanks to our director in her absence, and so also to all the trainee mediators, senior mediators, and all who have been participating till now. Thank you so much.
Okay, very nice.
ಬಾಟ್ಲ್ ಬರ್ಲಿಲ್ಲ ಇಲ್ಲ ಬೇರೆ ಬಾಟ್ಲ್ ಬರ್ಲಿಲ್ಲ